Like we have a Central Election Commission or Election Commission at the top level. We have a State Election Commission as well. But the Central Election Commission is responsible for the conduction of election for both the union and the state legislature. But for the third tier, it is the State Election Commission. Similarly, we have finance commissions at the state level as well. Anyhow, let's now move to another important body which is very close to your heart, and that is the Union Public Service Commission or the UPSC. Various constitutional bodies, one after the other. So we'll start everything with the Election Commission of India. Now, what is the task of Election Commission of India? Well, in very simple terms, it has one mandate, and that is to conduct free and fair elections. Now, you know, free and fair elections are indispensable for the functioning of any representative democracy, and therefore this onus has been given to the Election Commission by the Constitution. The Election Commission is a constitutional body, it is a permanent body, and it is an independent body. It means it is independent of the executive or the legislature. So let's have a look at it. The Election Commission is a permanent and an independent body established by the Constitution of India directly to ensure free and fair elections in the country. Now, it is Article 324 which deals with the Election Commission. So Article 324 of the Constitution provides that the power of superintendence, direction and control of the elections to the Parliament, elections to the state legislature, election for the office of the President and election for the office of the Vice President, all such powers shall be vested in the Election Commission of India. So Article 324 of the Constitution provides that the power of superintendence, direction and control of elections to Parliament, state legislature, the office of President of India and the office of Vice President of India shall be vested in the Election Commission. The Election Commission is not concerned with the elections to panchayat and municipalities, because we have seen in the last class that that power rests with the State Election Commission. Like we have a Central Election Commission or Election Commission at the top level, we have a State Election Commission as well. But the Central Election Commission is responsible for the conduction of election for both the union and the state legislature. But for the third tier, it is the State Election Commission. Similarly, we have finance commissions at the state level as well. Now, let's have a look at the composition of the Election Commission. It means how the Election Commission will look like. Article 324 of the Constitution has made the following provisions with regard to the composition of Election Commission. Now, it means how would be the structure of Election Commission. The Election Commission shall consist of the Chief Election Commissioner and such other number of election commissioners, if any, as the President may from time to time fix. It means the total strength of the Election Commission has not been prescribed in the Constitution explicitly. Rather, some powers have been given to the President to take a final call regarding the strength of the Election Commission. The Constitution just says in Article 324 that the Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any. It means if there is only a need felt by the President of India, which the President may fix from time to time. So it has been left to the subjective satisfaction of the President to determine the strength of the Election Commission. But if you see, for the last few decades, the Election Commission is functioning as a three-member body headed by the Chief Election Commissioner. The appointment of the Election Commissioner and other the Chief Election Commissioner and the other election commissioners shall be made by the President. The President obviously is the appointing authority for the Chief Election Commissioner as well as the other election commissioner, if any, in the Election Commission. When any other election commissioner is so appointed, the Chief Election Commissioner shall act as the chairman of the Election Commission. Now, this is very well understood because he is the Chief Election Commissioner. Therefore, he becomes the ex officio chairman of the Election Commission. Do you understand that? The President may also appoint, after consultation with the Election Commission, such regional commissioners as he may consider necessary to assist the Election Commission in its work. Now, here the point to be noted is the President may also appoint after consultation with the Election Commission and not the Chief Election Commissioner. With the Election Commission, such regional commissioners, if the President feels they are necessary to assist the work of the Election Commission. And what is the work of the Election Commission? Well, its main work is to conduct election for the union and the state legislature, for the office of the President and for the office of the Vice President. But that doesn't mean that it has only that work, it has other works also, but all works are related to the conduction of these elections. Directly or indirectly they are related to these conduction of elections. The conditions of service and tenure of office of the Election Commissioner and the regional commissioners shall be determined by the President. So it is saying that what will be the conditions of office and what would be the tenure of the office, all of that for election commissioners, not for the Chief Election Commissioner, for election commissioners and regional commissioners, if any, shall be determined by the President. So again you see that because these offices are created due to the subjective satisfaction of the President, obviously, of course, you leave out the Chief Election Commissioner's office because that is constitutionally mandated, but others are left to a kind of subjective satisfaction of the President, and therefore the President becomes the authority to determine their service conditions and tenure. For whom? For the election commissioners and the regional commissioners, if any. The Election Commission has been functioning as a multi-member body consisting of 3 election commissioners. But that doesn't mean that it cannot contain more than 3, because you see, what does the Constitution say? The Election Commission shall consist, it means it's a mandatory thing on it, shall consist of the Chief Election Commissioner. So it's a mandatory thing to have the Chief Election Commissioner and such number of other election commissioners, if any. So there is no mandatory provision attached to it, as the President may from time to time fix. So again you can see that subjective satisfaction angle of the head of the executive. Anyhow, the Chief Election Commissioner and the 2 other election commissioners have equal powers and receive equal salary, allowances and other prerequisites which are similar to those of a judge of a Supreme Court. In case of difference of opinion amongst the Chief Election Commissioner and or 2 other election commissioners, the matter is decided by commission by majority. It means obviously you can understand that the 2 election commissioners can outvote the Chief Election Commissioner. They hold office for the term of 6 years until they attain the age of 65 years, whichever is earlier. Now this is all you can understand, they are now determined as such. They can resign at any time or can also be removed before the expiry of their term. Let's have a look at how the independence of the Election Commission is ascertained, because the independence of Election Commission is indispensable for the conduction of free and fair elections. So let's have a look at the various provisions which establish the independence of the Election Commission. Article 324 of the Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Election Commission. And what are they? The Chief Election Commissioner is provided with the security of tenure. He cannot be removed from his office except in the same manner and on the same grounds as the judge of a Supreme Court. It means that he can be removed from his office by the President only when the Parliament in both the houses of, it means individually in both the houses of the Union Parliament, a resolution has been passed by a special majority and the charges such a resolution lay on the Chief Election Commissioner is proved misbehavior or incapacity. In other words, let's have a look at this. He can be removed by the President on the basis of resolution passed to that effect by both the houses of the Parliament with special majority, either on the ground of proved misbehavior or incapacity. It means in a like manner and on like grounds as the judge of a Supreme Court. Thus, he does not hold office till the pleasure of the President, though he is appointed by him. It means the doctrine of pleasure does not apply to the office of the Chief Election Commissioner. Keep that in mind very clearly. It is Chief Election Commissioner. The service conditions of the Chief Election Commissioner cannot be varied to his disadvantage after his appointment, again showing the independence of the Chief Election Commissioner's office. Any other election commissioner or a regional commissioner cannot be removed from the office except on the recommendation of the Chief Election Commissioner. So you can understand that here the Constitution gives an advantage to the Chief Election Commissioner's office over the other election commissioner's office or regional election commissioner's office, and there are certain protections which are given to the Chief Election Commissioner's office which are otherwise denied to the other election commissioner or the regional commissioners. Though the Constitution has sought to safeguard and ensure the independence and impartiality of the Election Commission, some flaws can be noted in it. And what are they? First, the Constitution has not prescribed the qualification, legal, educational, administrative, judicial, of the members of the Election Commission. So nothing has been said about that who would be fit to sit in the Election Commission. The Constitution is totally silent on it. The Constitution has not specified the term of the members of the Election Commission. The Constitution has not debarred the retiring election commissioners from any further appointment by the government. Now, you can understand that here these are some provisions which create a kind of aspersion regarding the Election Commission. Anyhow, if you ask me that of all the various bodies that are created by the Constitution, some bodies which have got the or which have received the highest veneration in the eyes of the public or enjoy a lot of public confidence, Election Commission is certainly one of them. The other bodies may be perhaps the Supreme Court of India, the Union Public Service Commission, and the Comptroller and Auditor General's Office. So these four constitutional offices, if you see, and I'm leaving the judiciary, if you see just these three, the Chief Election Commission or the Election Commission of India rather, the CAG's office and the UPSC, they have a lot of respect in the public eye. Now let us have a look at the powers and functions of the Election Commission to determine the territorial areas of electoral constituencies throughout the country on the basis of the Delimitation Commission Act of the Parliament. We already know few things about the Delimitation Commission and how the entire state is broken down into geographical units which are termed as territorial constituencies for returning members to the popular chamber. Anyhow, the Election Commission is to determine the territorial areas of the electoral constituency throughout the country on the basis of the Delimitation Commission Act of the Parliament. It is just implementing the Delimitation Act of the Parliament to prepare and periodically revise the electoral roll and to register all eligible voters. Electoral roll is nothing but the voter list. Clear? So periodically revise it, prepare it, and then periodically revise it, because some people may die and they need to be removed from the list. Then there are some people who would attain the age of 18 years, they must be included in the electoral list. So all these tasks fall into the purview of the Election Commission to notify the dates and schedules of elections and to scrutinize nomination papers. Self-understood. To grant recognition to political parties and allot election symbols to them. In fact, which party will be treated as a national party or a state party, these all decisions are made by the Election Commission of India. To act as a court for settling dispute, it means, again you can understand, a kind of quasi-judicial power relating to granting of recognition to political parties and allotment of election symbols to them. In fact, the election symbols are also allotted by the Election Commission of India. To appoint officers for inquiring into disputes relating to electoral arrangements. Like it can also have the power to cancel the elections if there is charges of, say, rigging, booth capturing, etc. To determine the code of conduct to be observed by the parties and the candidates at the time of election. You all might have heard about the model code of conduct. Now, what will be the model code of conduct and how it will be followed by the different candidates and the parties who are fighting the elections is determined by the Election Commission of India. Obviously, not in a high-handed manner, but after consultation with the various contesting parties. To prepare a roster for publicity of the policies of the political parties on radio and TV in times of election. You might have seen this, that over the FM radio or in the television or All India radio, you will have some time slots dedicated to different political parties where they would come and they would speak about their policies and how they would bring reforms in the government or they would bring changes in the administration if they are voted to power. So the Election Commission decides that roster, that which party will have what time to say and on what date. To advise the President on matters relating to disqualification of the members of the Parliament. To advise the Governor on matters relating to disqualification of the members of the State Legislature. This we have already seen in our previous classes. To cancel polls in the event of rigging, booth capturing, violence and other irregularities. To request the President or the Governor for the requisitioning. Requisitioning means temporarily handing over the staff necessary for conducting elections. Many times you would see at the times of elections, several teachers, even people working in the banks, they would be hired by the Election Commission, and for that time being they would be working under the total superintendence of the Election Commission of India, and once the election is over, they resume their offices in the concerned departments wherever they are working. To supervise the machinery of the elections throughout the country to ensure free and fair elections. To advise the President whether the elections can be held in a state under President's rule in order to extend the constitutional emergency beyond 1 year. Do you remember that two conditions should satisfy if the constitutional emergency is to be extended beyond a year, and one of those conditions was the Election Commission's report to the President with respect to the probability of holding election in the state, and if the Election Commission declares that it is impossible to hold the polls now, the constitutional emergency can be extended beyond a year, and this was added by the 44th Constitutional Amendment. But anyhow, let's have a look at this. To register political parties for the purpose of elections and grant them the status of national or state parties on the basis of their poll performance. Clear? So again, preparing the model code of conduct. देखो, अब अगर इलेक्शन कमीशन पे एक क्वेश्चन आता है तो बहुत ज़्यादा चांस है कि वो उसके कॉम्पोजिशन पे आएगा और it will come on its functions and powers, and you can understand that any of these statements can find a place in the question paper. Very simple. And let's have also look at the deputy election commissioners. Now, the Election Commission is assisted by Deputy Election Commissioner. They are drawn from the civil service and appointed by the Commission with the tenure system. They are assisted in turn by the secretaries, joint secretaries, deputy secretaries and under secretaries posted in the secretariat of the Commission. You know, of all high level officers, you can understand. At the state level, the Election Commission is assisted by the Chief Electoral Officer, who is appointed by the Chief Election Commissioner in consultation with the state government. Now, this is an important point to note. At the state level, the highest authority is the Chief Electoral Officer. Now, this Chief Electoral Officer is appointed by the Chief Election Commissioner, but after consulting the state government. Below this, at the district level, the collector as the returning officer. He appoints the returning officer for every constituency in the district and presiding officer for every polling booth in the constituency. So if you make it to the final list and you get the IAS, one important duty for you would be at the times of election to act as the returning officer of the district and see the overall conduction of the polls. Anyhow, let's now move to another important body which is very close to your heart, and that is the Union Public Service Commission, or the UPSC, another important body. The UPSC is the central recruiting agency in India. You know well about it. Articles 315 to 323 in Part 14 of the Indian Constitution contain elaborate provisions regarding the composition, appointment, removal of members, along with the independence, powers and functions of the UPSC. So keep this in mind. It is contained in part 14 of the Indian Constitution. Now let's have a look at the composition of the UPSC. The UPSC consists of a chairman and other members appointed by the President of India. Again, you see there is no maximum strength that has been prescribed in the Constitution that this will be the strength of the UPSC. But UPSC is generally, if you see, it is a 9-member or a 11-member body, including the chairman. The Constitution, without specifying the strength of the Commission, has left the matter to the discretion of the President, who determines its composition. Usually, the Commission consists of 9 to 11 members, including the chairman. No qualifications are prescribed for the Commission's membership, except that 1/2 of the members of the Commission should be such persons who have held office for at least 10 years, either under the government of India or under the government of a state. It means no qualification has been prescribed that who can be a member of the UPSC. Just one condition has been laid down, that 1/2 of its members must be such members who have at least 10 years of working experience under the center or under any of the state government. The Constitution authorizes the President to determine the conditions of service of the chairman and other members of the Commission. The chairman and the members of the Commission hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. Now, this line you will see mostly common with respect to the UPSC, and also you will find the same kind of condition with respect to CAG, and also keep this line with you, but do not memorize it, because there are some variations with respect to this as well, like when you see the Attorney General's office, because he holds office at the pleasure of the President, there is no such security. They can relinquish their office at any time by addressing their resignation to the President. Obviously, that's understood because the President is the appointing authority. They can also be removed before the expiry of their term by the President in the manner as provided by the Constitution. And how are they removed? They are removed if a report is presented by the Supreme Court, and Supreme Court on inquiry finds that they are now suffering from any kind of misbehavior. So let's have a look at this, the removal of the UPSC members or the chairman of the UPSC. The President can remove the chairman of any other member of the UPSC from the office under the following circumstances. If he is adjudged as insolvent, it means bankrupt हो गया वो, तो आप हटा सकते हो उसे. If he engages during his term in any paid employment outside the duties of his office, or if he is, in the opinion of the President, unfit to continue in the office by reason of infirmity of mind or body. In addition to this, the President can also remove the chairman or any other member of UPSC for misbehavior. So keep this in mind. Now, this is mostly, you can understand, this is a kind of incapacity, whereas this is misbehavior, and the second one is more of a conflict of interest kind of thing. But since these words are not explicitly mentioned, so no need of highlighting such words, but just for the sake of understanding, you can understand again incapacity, conflict of interest, misbehavior. These are the grounds on the basis of which you can remove the chairman or the members of the UPSC. However, in this case, the President has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court, after inquiry, upholds the cause of the removal and advises so, the President can remove the chairman or a member under the provisions of the Constitution. The advice tendered by the Supreme Court in this regard is binding on the President. It means if the Supreme Court on inquiry finds that any of these conditions are satisfied, and thus the member or the chairman, as the case may be, must be removed from the office, the President shall do it, because the advice given by the Supreme Court is mandatory, is binding. During the course of inquiry by the Supreme Court, the President can suspend the chairman or the members of UPSC, and this mostly because for the sake of a fair inquiry. Defining the term misbehavior in this context, the Constitution states that the chairman or any other member of the UPSC is deemed to be guilty of misbehavior if he is concerned or interested in any contract or agreement made by the government of India or government of a state, or participates in any way in the profit of such contract or agreement or in any benefit therefrom, otherwise that has a member and in common with other members of an incorporated company. So you can understand that these are the two grounds which highlights that what tantamounts to misbehavior. Clear? Let's have a look at how the independence of UPSC is maintained. The Constitution has made the following provisions to safeguard and ensure the independence and impartial functioning of the UPSC. The chairman or a member of the UPSC can be removed from the office by the president only in the manner and on the grounds mentioned in the Constitution. And you understood that incapacity or misbehavior, conflict of interest, these are the grounds. Even misbehavior is defined. So there is a kind of security of tenure in that regard. Second, the conditions of service of the chairman or a member, though determined by the president, cannot be varied to his disadvantage during his term in office. It means the president can declare that what are the conditions of service, but he cannot diminish those conditions during the term of office. Again, a kind of clause which gives a kind of independence with respect to UPSC's functioning. The entire expenses, including the salaries, allowances and pensions of the chairman and members of the UPSC, are charged on the Consolidated Fund of India. It means they are not votable in the parliament. The chairman of UPSC, on ceasing to hold office, is not eligible for further employment in the government of India or a state. Similarly, a member of UPSC on ceasing to hold office is eligible for appointment as the chairman of UPSC or a state PSC, but not for any other employment in the government of India or of a state. The chairman or a member of UPSC is, after having completed his first term, not eligible for reappointment to that office. Though a member can be appointed as the chairman, but the chairman cannot be reappointed as the chairman. That is not eligible for second term, any of them. Clear? And this highlights their independence, so that they do not function in the hope that they would get a second term.